The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Daniel J. Bolin. On the agenda today, we're hanging out in the park because it's the summertime, cracking open a session in the 2021 IAPD IPRA Soaring to New Heights Conference. But first, let's take the roll. Behind the glass, for our protection, Engineer Rick is present. We have a quorum. Dear listener, the weather's getting warmer, which is why we packed our cooler with a session from the January 2021 IAPD IPRA Soaring to New Heights virtual conference. It's the Property Brothers Park Edition with Ansel Glink's Greg Jones and Kurt Asprey. With the Property Brothers, you'll learn the ins and outs of purchase, sale, and lease of Park District property. And the topics include what you'll need to know to evaluate property-related proposals from private and public sector entities alike, and how property transfers can help advance an organization's mission. You'll learn about the techniques and requirements for parkland deals for sale, lease, and acquisition, and hear how thinking outside the box might be the direction for future parkland deals. Thanks to the IAPD and IPRA for letting us share this session recording with you today. The call for proposals for the 2022 IAPD IPRA Soaring to New Heights Conference is now open. To submit a proposal for program consideration, please visit ilparksconference.com. The deadline for submissions is Monday, June 14th, 2021, which, if you're listening to this when it first comes out, will be in your near future. The link is also in the show notes to this episode. Check it out. Of course, Greg and Kurt need no introduction because, of course, they will introduce themselves on the recording. If you'd like to see a video of this presentation and the wonderful slides that Greg and Kurt are sharing, you can see it all on youtube.com/Ansel Glink. Now, without further ado, it's time to bro down in the park with the Property Brothers, Greg and Kurt. Engineer Rick, roll it.
Hello, I would like to welcome everyone to Property Brothers Park Edition. It's a pleasure talking at all of you through your computer speakers today. And I want to thank the IAPD for hosting this session and inviting us to speak on a topic that doesn't involve a discussion of social distancing, masks, or anything else that we're hoping to leave behind us in 2020. That said, to make all of this a bit more familiar or comfortable of an experience, please feel free to put a mask over your speakers or sit at least 6 feet away from the computer, or better yet, go on outside on this beautiful January day and enjoy our presentation. My name is Greg Jones. I'm a partner with Ansel Glink, and I'm on the screen, the one with the orange hair. Much of my practice focuses on helping public and private sector clients addressing real estate, land use, and zoning issues. With me today is Kurt Asprey. He's also a partner with Ansel Glink. Thankfully, Kurt doesn't also have orange hair. That would be way too much orange hair. But Kurt, I'll let you introduce yourself and say a little bit about yourself.
Yes. Welcome, everybody, and thank you for joining us on this unique presentation format here. My name's Kurt Asprey. I'm a partner with Ansel Glink. I work with all types of local governments, park districts, municipalities, townships, school districts, and just on day-to-day, corporate work and everyday items. But I also do focus, along with Greg, heavily on land use and zoning and real estate matters, which will hopefully be able to give you some background in today. And yes, and again, apologies for the slide there. That photo is just something else. Yeah. We certainly can't say doing justice to the actual Property Brothers there.
No, I think this is about as good as we're going to get for 2020, even though we're in 2021. And I'm going to keep using that excuse well into 2021.
Absolutely.
All right. Thanks, Kurt. So we have a lot of ground to cover today, no pun intended. But we wanted to start by taking what can be a topic that lives at about 15,000 feet down to the ground level. up on your screen is a picture of a property that a park district, in this case, the Naperville Park District, wanted to convert to programmable active recreation space. And based on the picture, it's apparent how much vision and imagination was required to make that happen, or even conceive if that was possible. This is a heavily wooded site that is bisected by a river. It looks like there is a white paper bag stuck in a tree branch on kind of the left half of the screen. Certainly not what you would expect when you think of outdoor active recreation space. This slide shows an aerial photo of the site we just had. It's kind of outlined in yellow. It's noted as the possible site for acquisition. It's located south and west of a park, Nike Park, that had some programmable space. There's a few ball fields, a soccer field, parking facilities. To the east is a residential neighborhood that's fairly well established and been there for some time. And you'll even notice down around the south boundary of the acquisition site are a couple of holdout single-family homes. And then there's a 4-lane road on the west side of the site as well. So lots of challenges with this site, but also a good deal of opportunity. As an aside, I worked on this project back when it was going through, although not for the park district. I was working for the city at that time. So this isn't just an academic exercise for me. I lived it, and better yet, lived to tell about it. And I'm looking forward to kind of using this as the frame for today's discussion. So this slide shows an overview of the 4 general topics we'll discuss today. I'll focus on acquisition and some pre-acquisition diligence topics, and Kurt's going to cover the remaining topics. So let's jump into it. Before a project becomes a project, it's really nothing more than an idea. And to convert an idea into something tangible, park districts need to first understand as much as they can about the property that they want to develop. That includes what land use and zoning regulations and restrictions apply to the property, what land use policies may apply. Those are typically adopted by the municipality if it's located within a village or a city, or the county if it's located in a county, unincorporated property. And understanding what governmental entities have jurisdiction over. So all of this kind of goes into the pre-acquisition diligence process, and we're going to walk through some successful strategies on how to navigate that here today. So let's start with zoning. Zoning is not a 4-letter word, although it often feels like it. And this is really the subject or the topic that causes perhaps the most intergovernmental angst in the development process for park districts. As many of you know, park districts are subject to local zoning authority. So if the property is located within a municipality, you have to comply with the municipality's zoning laws. Similarly, if it's located in an unincorporated area, you have to comply with the county zoning ordinance, assuming they've adopted one, and many or most counties have. This is a kind of an uncomfortable position for park districts to be in. As a unit of government, park districts are typically more used to establishing and enforcing rules, not necessarily having other units of government impose rules on them and tell them what they must do. Adding a level of complexity to this as well, a lot of municipalities don't place as much of an emphasis on outdoor recreation as park districts do. Municipalities tend to focus more on tax-producing uses. And this mindset has been around for a long time. It's starting to change a bit. And we're seeing more and more municipalities that have adopted municipal plans that have sections or even a whole chapter that focuses on concepts like wellness and walkability and things like that, which actually align pretty nicely with a lot of the policies and goals contained in some rec plans and master plans for park districts. But change is hard and change is slow, and there are a lot of communities that haven't started doing this yet. So courts in Illinois, it's important to know, including the Supreme Court, have evaluated the land use relationship between municipalities and parks. The case that's most notable or most relevant for today's discussion involved the Wilmette Park District, the Village of Wilmette. There was a dispute over the Park District's plans to put up lights, large, tall lights in a park. The village had reviewed the plans that the Park District submitted and reviewed the village's zoning code and determined that the Park District needed approval of a special use permit before putting up the lights. The Park District didn't really like that response. They were even less excited about having to go through the public zoning review process and decided it would be easier to sue the city instead, or the village instead. The court held that park districts were subject to local zoning authority at the end of that lawsuit, and that is still the law of the land today. However, there is a limited exception. Municipalities can't administer their zoning codes in an unreasonable, arbitrary, or discriminatory manner when reviewing park district projects. So in other words, municipalities can't act to intentionally thwart the park district's statutory duties to provide recreational opportunities. So there are some limits on how a municipality can act within this land use relationship between park districts and cities, but there aren't a lot of limits. And the takeaway here is that you're going to have to go through a zoning process if your proposal doesn't comply with the local zoning regulations. Okay, we've established that park districts must comply with local zoning regulations. There are 4 primary steps in the local zoning review process. And it's critical for park districts to approach each step with care and thought. And we'll walk through just how to do that. First up is the pre-filing step. And this step covers everything that the park district does generally before it engages the city in discussions about zoning approval. Just as a footnote, I'm going to say city here. If your park district is developing property in an unincorporated area, just imagine I'm saying county every time I say city, and it will make sense. So on the pre-filing step, it's critical to line up public support for the project. Park district voters are city voters. City elected officials understand that. They like to keep their constituents happy. That's how they stay in power. Residents are uniquely situated to tell the story of why the park district's project is needed. And it's really important for park district to recognize that and harness that power for the district's purposes. The district also needs to review its own policy documents, including its master plan or its rec plan, to confirm that the project that they're pushing forward advances the district's mission. Data and metrics are particularly helpful here. If the district can demonstrate and quantify a need for the project, that will go a long way towards supporting and ultimately implementing the project. Districts can rely on master plans, rec plans, enrollment data for programs that are over-enrolled or they've had to turn folks away. Survey data, if your park district regularly polls its constituents to see what types of opportunities, recreational and otherwise, they would like to see the park district offer, and other outreach methods. All of these are tried and true. There's no right way to do it. There is a wrong way to do it. And that is collecting data that is questionable or using means that don't sufficiently sample constituents. So keep an eye on how you're collecting the data, because sound data, again, is a great way to support your proposal. Park district also needs to carefully consider how its intended use of a property may impact neighboring uses. So what's going on next door? The Naperville project we discussed earlier was not in a field all by itself. Adjacent to a single family neighborhood, and there were a couple of homes that were surrounded on 3 sides by the parks. Residents generally don't want ball field lights shining through their bedroom windows. And the district understood that early on in the Naperville case, worked to engage those residents to discuss possible solutions from a design standpoint, primarily including buffering, shielding of lights, things like that. So conducting that issue spotting exercise early is critically important to the success of a project. You never want to get to the point where you're going to a public hearing and for the first time you have someone come out saying, I just heard about this project and there's going to be a 30-foot light tower in my backyard, and if that has happened, then you've missed a step in the process. You need to logically, thoroughly think through who may be impacted by your proposal and try to engage them early to either win their support or, if you can't, because it's not always possible, at least demonstrate to the city that you've tried. And here's why the solution, or here's what the solutions are. They might not keep everybody happy, but you're thinking about this and you're trying to be as considerate as possible. And finally, I know Kurt's going to touch on this a little bit later, but it's critical to obtain a title commitment for the property that you're going to develop or acquire, to review any restrictions or covenants that have been recorded against the property. Covenants commonly limit how a property can be used and developed. You need to ensure that the district's plans for the property don't conflict with those recorded covenants. Okay, continuing on the pre-filing step. And we touched on this a bit earlier, and it's pretty basic, but you need to understand whether the property that you want to develop is located within a municipality or a county. This will ultimately determine who needs to approve the project. County boards consider proposals for zoning relief for projects that are located in unincorporated areas, and village boards or city councils consider proposals for properties that are located within their corporate boundaries. Interesting to note, if a property, an unincorporated property, is located within 1.5 miles of the municipal boundary, the district will likely need to comply with both the county's zoning rules and the municipality's subdivision rules. This 1.5 mile area surrounding the municipal boundaries is the extraterritorial jurisdiction area. So there's some special rules that apply. And if you're lucky, you could have a project that needs to be approved by just about everybody. Of course, I'm kidding, but keep an eye on that. And there are several layers of regulations that may need to be navigated depending on the property. It's also worth considering whether the park district has a better relationship with county or city officials. This commonly plays a role in determining whether it's worth pursuing annexation of a development site before developing or as part of the development process. This is a kind of a legal way to forum shop. If you don't have a great relationship with the county and your property is eligible for annexation and you've got a good relationship with the municipality, you may want to consider annexing the property to get it out of the county's jurisdiction, and that way you're just dealing with hopefully a more sympathetic ear with the city. Oops, skip ahead there. Okay, let's spend a quick minute on annexation. Annexation is not always possible. There are legal requirements that properties must meet to be eligible to annex. Specifically, a property must be contiguous to a municipal boundary to annex. So it has to be touching the municipal boundary for that unincorporated property to be eligible to apply to annex into the municipality. The municipality also has to approve the annexation. They can always say no. In a lot of cases, municipalities are open to and welcoming of annexation. It expands their boundaries, which can open up additional annexation opportunities in the future. It brings property under their zoning control and local control, other ordinances, which is generally a good thing. But annexation can cut both ways in these cases, and it's important to think about this carefully before simply filing an application. Many cities view annexation as an opportunity to exact concessions out of the party that wants to annex. That can significantly increase project costs and complicate the review process. A good example of an exaction is, a property that wants to come in, and the municipality obviously would provide utility services to the property, but there's not a utility main located within 1/2 mile of the site. So as a condition of annexation, the municipality may ask that property that wants to annex to extend the utility main 1/2 mile to its site at significant cost. That's a long enough run to kill many, if not most, projects. So those are some issues that can come up. But on the other hand, a successfully negotiated annexation agreement between a park district and municipality can secure concessions for the park project, and particularly when the park district has done a good job of demonstrating that there's clear public support for the park project, which commonly resonates with municipalities. All right, let's move on from annexation to the application. So this is the application for approval for from the municipality. Once the district's pre-filing step is complete, it's best to dig into and review other relevant land use documents. These will be documents that have been approved by the city, and will address a variety of different land use related topics. Some forms include the zoning map and the zoning ordinance. These documents are particularly important here, and they tend to communicate the village's land use policy as it relates to the property and neighboring properties. The zoning ordinance identifies what uses can locate on the property, where they can be located, and generally any conditions that the park district must satisfy before using the property the way that it wants. The zoning map is also important, and it's helpful in detailing a community's vision for the surrounding area. If a potential park site is bordered by residentially zoned property, the district may want to think twice about putting its highest water slide in the water park adjacent to those properties. So both of these documents can both inform the district on how property can be used and kind of influence the site design process too, because there's a way to mitigate some of these impacts. The subdivision ordinance is also important. It will tell a district whether the property must follow the statutory subdivision process and what improvements the district must construct and pay for as a result of the subdivision. So let's take a quick minute here. In the municipal context, so whenever the municipality reviews a development proposal, whether it's from a park district or a private developer or anybody, whether or not that property needs to be subdivided is the most common trigger requiring the developer to install public improvements like sidewalks, street lights, utility extensions, and other infrastructure that can and commonly is incredibly expensive, depending on the size of the site, depending on the types of utilities in the area. So it's commonly a big number. It's also commonly a variable number. No two sites are exactly the same, and it depends on the part of town that you're trying to develop in. So understanding the subdivision ordinance early on is very important because it will help you put your project budget together and figure out whether or not this can actually be funded in this year's fiscal cycle, next year's, or at all. Park District should also review the city's comprehensive plan. The comprehensive plan typically details what the community will look like in 5, 10, 15, or 20 years from a land use perspective. It sets forth the vision of the community. Understanding the plan's recommendations early on will allow the district to plan accordingly and align its project with the plan's goals to the extent possible. Projects that are consistent with the city's comprehensive plan tend to attract much more support, both from the public as well as from city staff, who is a critical ally in the zoning review process. So again, educate yourself on the comprehensive plan and go forward knowing whether or not your plan is in support of it, or if it isn't, you can try to make some changes, or potentially even ask the city to amend its comprehensive plan. That's happened sometimes. It's not a real common occurrence, but it can help projects that weren't necessarily foreseen when the plan was adopted 10 or 15 years ago move forward. And just one last note on the application documents. It's a really good idea for park districts to obtain the village's zoning approval form, so the applications early on. The content and detail associated with these applications varies widely depending on the community. Some communities require a great deal of information in order to submit an application. The communities only require a page or two of basic contact information and property information concerning the site. But regardless of the level of detail required, obtaining these application forms early on will allow the district to understand the community's expectations, adjust its plan accordingly, and ultimately submit an application that is consistent with what the village expects to see. All right, our next step, once we've done all of our homework there, is to schedule our first visit with city staff. And this is a really important step that is often overlooked in the process. Before you go and sit down with city staff, and commonly the planning director or the zoning administrator, somebody in the community development department is normally your first stop here. It's wise to have the project's big details ironed out. It also helps to think about all the documents you just reviewed and what potential issues the city may raise based on your project's compliance or lack of compliance with those documents of policy. Presenting a thoughtful proposal early on, right out of the gate, will show the city that the park district is serious about the proposal. It'll show that they're organized, and it'll show that they're ready to move forward. If you don't do that, cities commonly pick up on it right away, and they will respond with a like amount of attention and interest. So presenting a half-baked or less than that proposal isn't the best way to get staff's attention or support on your application. The meeting with staff also provides a great opportunity to understand what experts the district may need to hire to successfully navigate the city's zoning process. Again, this varies from community to community, and we'll talk about it a little bit later. But that's another key takeaway. And also to learn the city's process for how proceedings are conducted in front of the hearing body. So this is typically the Planning and Zoning Commission. Under Illinois law, the Planning and Zoning Commission is statutorily required to conduct hearings on specific zoning applications and offer recommendations to the City Council. That planning and zoning hearing is frequently the longest and most involved meeting in the public zoning review process. That's where all the neighbors get to come out and speak their piece and participate in government. So it's really important to understand the rules about how that hearing is going to function. And so you can plan accordingly and make it as efficient and successful of a hearing as possible. One final note on this. This meeting with staff, it doubles as a project introduction and a reconnaissance mission, I guess, for lack of a better term. You can learn a lot about a community from this initial meeting, and it's a wonderful opportunity to make village staff an advocate for your project. Few projects, whether it's an application submitted by a park district or a private developer or your neighbor, few projects succeed when the applicant takes an adversarial approach with village staff. So going in prepared, going in ready to provide the answers you have, going in and being open in your discussion is an excellent way to make village staff an advocate and an ally in this process. And that can make the public hearing process, which is full of unexpected surprises, a little bit more predictable. Experts. All right. Experts cost money, which no one likes to spend unless they absolutely have to. But it's often necessary to get experts involved in a project, and particularly if a city recommends or requires that you do so. Trying to perform, from experience, I can say trying to perform expert tasks in-house has the uncanny potential to both delay the approval process, the public zoning review process, and cause, this is equally as important, and cause village staff to lose faith in the project. And it's important to kind of put your village staff hat on when you're thinking about who you're going to hire. In many cases, village staff is trying to find a way, trying to find data, objective justification to support your application, to support your project. But they need your help. So that's where the experts come into play. You hire an expert to provide a traffic study or a parking study indicating that the parking supply that's been proposed is sufficient to meet the program spaces. Things like that. It's uncommon for a park district to have that type of staff on hand that can produce that type of report that has the professional credibility that village staff would be willing to look at and hang their hat on and say, yes, we agree with this, we'll go to bat for you. So we know it costs money, and again, nobody likes spending money, but it's important to involve experts appropriately in projects. What types of experts? Land planners, a variety of engineers of different professions, certainly civil engineers if you're building something, and traffic consultants are typically the most common experts you see involved in zoning consideration for park district projects. And after we've done all that work, you get to go get yelled at by the neighbors. I mean, meet with the neighbors. So this is a critical step that a lot of park districts miss. The neighbors, again, are voters. They are voters in the city. They're your constituents. The city will respond to their complaints. They are absolutely stakeholders in this project, and they should be treated as such. So when you meet with the neighbors, first of all, you need to meet with the neighbors. That will show the city that you're trying to approach this from a thoughtful, considerate manner and not trying to jam a project through. Once you do meet with the neighbors, you need to be sure to listen to them, to document their concerns and to demonstrate how you can respond to their concerns. You're demonstrating that to the village. The village is going to ask if you've sat down and met with stakeholders and neighbors to talk about the project. Some communities even require that as part of their zoning review process. There's a mandatory neighborhood meeting. We have to send out notice to everyone within 200 or 250 feet, and they come and you have an open house and you share your plans with them, and then you report back to the village on the feedback. This is becoming increasingly common because communities want to try to limit the number of surprises that come up during the public hearing itself. So they're shifting some of that burden onto the applicants to meet with folks sooner. Even if you're not required to meet with them, it's a good idea to do so. It's good opposition research. You're going to get an indication of what people's concerns are, and then you can go back and huddle with your team and figure out how you can respond to them. Sometimes you can modify the plan to appease those concerns. A lot of times you can't, but just the exercise of identifying the concern, thinking about potential solutions, and then if that objector shows up at the public hearing to talk about how I met with the park district and told them I was worried about this, and this is the exact same plan they brought back up, and they aren't listening to me, then you've got a great response already in the can. No, we met with you on one or two occasions. Here were your concerns. Here's how we looked at making some changes. Here's what we did on the one hand, or here's why we can't make these changes and explain the reason why. So that's a really critical step in the process. It'll make public hearing and public review process go much more smooth. And all of this leads up to your planning commission hearing or planning and zoning commission hearing. Sometimes it's the zoning board of appeals that's conducting the hearing. Regardless of who's conducting it, it leads up to the hearing. Legally, before the hearing occurs, the park district must provide public notice of the hearing. Statutorily, you're required to publish notice in the newspaper. There are some local requirements that some communities impose too. Some communities require you to post a sign on the property. Other communities require you to mail letters to properties that are located within 250 or 300 feet of the property, notifying individually each recipient of the hearing and inviting them to attend. It's important to recognize this not as a burden, but as an opportunity. And there's a great opportunity for park districts to transform these notice requirements, these legally, statutorily required notice steps, into advocacy opportunities. And particularly if the park district is sending a letter to the neighbors to notify them of the hearing. Don't just send a letter that says, we're applying for rezoning from R1 to R3 to build a park. That's what you're legally required to provide. And certainly if you did that, you could still go ahead and have a hearing. But think of this from a marketing perspective and talk about why the district is pursuing the project at this time. Identify how the project is consistent with the park district's policies and public feedback received to date. This is as much a pitch as it is a notice. And by providing concise information that highlights the benefits of your proposal to the public, you may win some advocates, or more likely, because the only people that come out to public hearings are typically the folks that want to complain. So even if you're not winning advocates, you might encourage some people to stay home, which, again, that's not a bad thing. You're providing them with the relevant information that they need in order to make a determination on whether or not they want to participate in the public hearing. You're doing that for them. You're making their job take a night and come out to a public hearing and scream and yell about the park district and its proposal. And that concludes the first part of the presentation, covering kind of the zoning diligence and gearing up for the public hearing process. I am going to hand it over to Kurt to talk about the other aspects of property acquisition and management.
Yes.
Also
yeah.
keep in mind.
Thank you, Greg. Thank you, Greg. So I'm going to go through some more of the kind of specifics about how a park district would go about acquiring property and some of the concerns and issues that come during that process. So that's the zoning process. We're going to go through some of the details when you're actually going through the acquisition process here. So Greg mentioned earlier, and we highly recommend it anytime a park district is going to be purchasing property, obtain title insurance. It's going to be very important. You're going to get a title report that's going to show you anything that's recorded against that property. So easements, covenants, like Greg referenced, any other liens, a mortgage. Sometimes these title reports will come up with something that you really weren't aware of that might, make the property not feasible for the park district anymore, or not something that you're able to be, go through. If there's somehow if there's a mortgage on it that hasn't been satisfied, a park district's not going to want to take that property subject to that mortgage. So title insurance is also going to protect the park district after the purchase is completed, because if there's some, challenge to title, you're going to have that title insurance to rely on. So always a good idea to pull a title commitment and obtain title insurance. Surveys are another pre-acquisition step that you certainly want to carefully consider obtaining one. A lot of times a property owner might have an older survey that they had commissioned when they purchased the property. Sometimes those are pretty old, so always consider maybe getting an updated survey. That's going to really make sure that you know what the bounds are of that property, and if there are any other easements or other issues that are going to be shown on that survey. So always a good idea to get a survey. Environmental issues, this is another concern that comes up, and sometimes a lot of time, local governments and park districts don't really think about this. Is you really have to look at if there's going to be any environmental issues. Sometimes if a property is contaminated, if it had some type of industrial use on it and it's got something in the soil, if you buy that property and later on down the road there's an issue with that contamination, you might be on the hook for it. So always think about investigating whether or not you need to do some environmental analysis. The most common one is that we recommend is just a phase 1 analysis. It's a non-invasive analysis that includes a site visit, interviews, a review of public records, and that's going to kind of give you that baseline to say, do we even think there's a possibility that there's environmental contamination here? If it looks like there might be, you might need to get a phase 2 assessment. That includes soil borings and groundwater well tests and other investigations there to determine if any specific types of contamination might be present. So they're going through these phase 1 and phase 2s can help establish what's called the innocent landowner defense, because there are some potential repercussions under federal law that impose strict liability for pre-existing contaminations, even if that property owner was not the cause of those contaminations. So always keep that in mind and look into whether or not a phase 1 is always a good idea, just to kind of make sure you're covering your bases there. If there's a potential that there was some environmental contamination. So those are some of the basics there. And now we'll get into how park districts can acquire property. So there's lots of different options here: gift, legacy, grant, purchase, and condemnation. This can apply to property both within and without the park district, although condemnation, eminent domain, can really only apply to land that's located within the park district's boundaries. And now we'll go kind of step by step here. We'll look at each one of these. So gifts, sometimes a person will want to gift their property to the park district. Do you have to accept that gift? No, that's up to the park district. It's not mandatory that if somebody wants to give you their land that you have to take it. And I think, the comment that we see in this is, should you look a gift horse in the mouth? Yes, you should. You should decide if this property actually makes sense for the park district. If you want it, if you need, do your due diligence. It might be that they're trying to unload this property because it has a bunch of environmental contamination on it, and it's not something that the park district would want to take. Or, it's a piece of property that's, burdened with floodplain or floodway, and there's really nothing you can do with it, and the park district's just going to be stuck taking care of a piece of land that they can't utilize. So, always look at that and see if it's something that the park district wants. There's also legacy donations to the park district. That's basically a form of a gift that someone basically includes in their will or as a bequest that they're going to give such property to the park district. Sometimes this is prearranged. Sometimes the park district is aware of it. Sometimes the donor will say, hey, I'm including this bequest. I want to make sure you're aware so that you know. Other times it's a surprise. Out of the blue, you'll get contact saying that, this piece of land has been donated to the park district there. Just like a gift, you don't have to accept it. You should really look carefully and see if the property makes sense for the park district, if the park district is going to be able to make use of that property. And in either case, for a gift or a legacy, make sure that it's really well documented when the gift is made and if the park district is going to accept it or reject it, because you don't want there to be any ambiguity down the line if an actual parcel of property was in fact accepted by the park district. So be careful about that. Always really carefully document when you're either accepting or declining a gift or a bequest, because there are concerns there. Yes, Greg.
Just a quick note on that too. It's pretty common for a lot of our park clients to actually enter into a donation agreement.
Yeah.
Which that can be for either personal property or real property, so land or stuff. And that can really help clarify the intention of the donation, how the park district can use it, what its obligations are moving forward, things like that.
Absolutely, absolutely. We highly recommend crafting a donation agreement that's going to make sure everybody understands the terms of that donation to the park district. So that's a great point. That's absolutely something you should do if you have somebody or wanting to donate property to the park district. So then generally, how is this property granted to the park district? Obviously, the most common everybody's familiar with is through a deed. And that can come through private property owners, or in some cases that we'll get into here from a municipality or another unit of local government. And that brings us to the Local Government Property Transfer Act. So this is it's a really useful and helpful act, frankly. It provides kind of a streamlined process for park districts and municipalities to exchange real property. There are, and we'll touch base on this a little bit here, how park districts can sell and acquire property sometimes can be, and how municipalities and other local governments too, there's lots of steps that they have to go through if they're selling property or conveying property to a private entity. The Local Government Property Transfer Act kind of says it creates a process that if that property is going to be transferred between two local governments, they can kind of streamline that and don't have to go through all of these kind of sometimes burdensome steps. So in the case of the Local Government Property Transfer Act, a municipality would decide that they want to convey a piece of property to a park district. The park district has to pass an ordinance declaring that it's necessary and convenient for the park district to use and occupy that piece of property that is held by the municipality. After that, the municipality is going to pass their own resolution adopting that and deciding to convey that property to the park district. Has to be approved by 2/3 of the board that's conveying the property. And the other real great thing about the Local Government Property Transfer Act, it allows you to set the terms for whatever that sale is going to be. So if there is any monetary consideration, that can be set forth within those ordinances and resolutions. If there are any other limitations or restrictions on the property, there's a process there to work to have those restrictions removed. You can actually go to court under the act to try and have a restriction removed if you're unable to have it removed directly by the mortgagor or the grantor there. So it's a really helpful act. You don't have to follow a lot of the other kind of onerous provisions to acquire property there. So if you do have a good relationship or if there is a piece of property that a municipality has that they're not really interested in developing or maintaining, but that might work for a park, reach out. And this is the Local Government Property Transfer Act is a great way to kind of facilitate that in a streamlined process there. Next is dedication. This is, I think, a real common way that park districts acquire land, or at least a increasingly common way. And the there's two types of dedication. There's a statutory dedication and a common law dedication. But in essence, a dedication is where somebody has said, I designate this piece of land and I'm going to dedicate it to the public to use in perpetuity. So it's not conveying it, through a deed per se. It's basically saying I am hereby dedicating it to the public without going through the conveyance process. So in a statutory dedication, you have to follow what's called the Plat Act. And Greg mentioned subdivision regulations earlier. And in most instances, the Plat Act requires somebody who's subdividing property to ensure there's sufficient amounts of land set aside for streets, roads. Those are the most common pieces of property that are dedicated to the public, but also for drainage, other issues, and then parks. So a lot of times, if there's a new subdivision coming in, there will be open space dedicated as a public park and could be dedicated specifically to the park district. So that's a statutory dedication when it's completed by a plat. And you can't just have, demand that huge amounts of space be dedicated to a park district when somebody's subdividing land. Illinois has what's called the specific and uniquely attributable test. So that means if you're, if you have a subdivision of 100 homes and you're expected to have an additional 200 kids in that subdivision, you could require that they dedicate land for a park that's sufficient to serve those, expected 200 kids. That's a specific and uniquely attributable response there. But if you're subdividing land and you're going to have one residence on it, you can't require that they dedicate a huge amount of space for a park. There's really no relationship between what the subdivider is doing with that land, the relationship between the subdivider and what's being exacted from that person. So that there is some limitations there. Many local subdivision ordinances actually have formulas for how much land has to be dedicated, given on how many residences are being created or how much land is being subdivided. And that sometimes can also include impact fees, which I'll touch on in a minute here. You should carefully monitor your municipalities or the county's land dedication and park dedication requirements. Make sure that they're being followed. Sometimes they might get missed. You want to make sure that if there is a requirement that they donate land to the park district when somebody's coming in and building a new subdivision, you want to make sure that the park district is getting it. And then follow through when there is going to be a donation to a park district through a statutory plat or even through a common law dedication here. The municipality can require it and they might mandate it, but sometimes they're not going to follow through and make sure that process happens for you. So follow up with the municipality and the developer and make sure that everything's tied up so that you have that land dedicated and everybody knows that it's going to be the park districts moving forward. Common law dedication is the other way that land can be dedicated to public use, such as a park. This is where basically the requirements of the Plat Act were not satisfied. So there either wasn't clear on the plat that it was meant to be donated to the public, or there was some other deficiency in how the plat was executed and recorded. That doesn't mean that you still can't dedicate land as a park. Say if somebody, there still has to be expressed donative intent by the grantor. So if somebody opens up a piece of land and says this is going to be a public park, and the park is used by the public, for a long time, and it starts to be maintained by a park district, there could be a finding there that there was a common law dedication of that land as a public park. So you have to have that donative intent, and then there has to be acceptance by the park district. So in a common law dedication instance, that acceptance is usually manifested by a park district performing maintenance, expending money to upgrade it, or otherwise having some type of formal resolution or ordinance passed saying that we are hereby accepting that land as a park. So sometimes the dedications include restrictions. Sometimes on the plat it will say hereby dedicated to the Naperville Park District for use as a public park in perpetuity. Sometimes they can have it be a little bit more specific. Those whatever's in those restrictions in the plat are going to have to be complied with. So just make sure that when you are dealing with parkland that has been dedicated through a statutory plat, that you're being consistent, you're using that land consistent with what that dedication was. So if somebody wants to donate land to you and there's a restriction on it that it can only be used as, open space and not have any structures ever built on it, but you want to use it to build, a rec center, that property is not really going to make sense. So make sure you look at that carefully, because there can be some restrictions through a dedication as well. Impact fees also come up in this instance when somebody's subdividing land. Again, Greg touched on this briefly, but when a developer is coming in, going to build a new subdivision, not only might they have to donate land to a park district, but they also might have to pay impact fees when they subdivide. The vast majority of those impact fees are generally going to go to schools. I'm sure most everybody's familiar with impact fees that go to schools to try and ensure that when there's going to be 100 new students coming in, that school has money to accommodate those additional students. Same thing with parks. The guiding principle is that growth pays for growth. So if a developer is coming in and building all these new homes, and those homes are not on the tax rolls yet, and there's going to be some catch up there before they're actually paying their fair share, that's why you have these impact fees, to make sure that they're paying for that additional growth. Only municipalities have the ability to impose impact fees. Park districts do not. So check your municipality subdivision ordinance and see what their impact fee and land donation requirements are for park districts. In some cases where there's like a land donation requirement for a park district that a subdivider might have to fulfill, either if donating land isn't feasible given the shape of the development or how it works, or if maybe the park district doesn't really see the land as a beneficial to the park district, you could do where you can do what's called a cash in lieu of a donation or land donation. So that's another thing to look at as well, where the developer will, instead of donating land to a park district, pay essentially an impact fee instead. So, but that's up with your municipality or in some cases the county. So check your local regulations and see what they require, and make sure you're keeping up to date on that if there is a lot of new subdivisions being developed in your park district there. Now we'll move on to purchase, condemnation, and leasing. So there's a few different ways park districts can acquire property. Obviously, you can pay for property. You can pay money up front and buy that property outright through a purchase and sale agreement. But you can also condemn property. This is the power of eminent domain, and park districts do have that power generally, but it can only be exercised on land within the park district, and it's an involved process. So eminent domain is not something that you can do very quickly and obtain title to property. It generally involves a lengthy legal process where you have to establish what the highest and best value of that property is, and then that ends up what the park district would pay for that land. So it's called the payment of just compensation. So eminent domain is something to look at, but it's probably not the first avenue that a park district would pursue to obtain property. It's probably more of a last resort if you're unable to work with a property owner to purchase it or acquire it through other means. How can a park district pay for property? Obviously, you can pay cash if you have the reserves for it. You can also issue bonds, but again, be careful. There's debt limits out there, so you have to make sure that you consult with bond counsel before any bonds are issued to pay for any purchase of a property. Park districts can also lease property. You can lease property for a period not to exceed 99 years, so you could have a pretty long lease. Park districts can make capital improvements to that property that they have leased, and they can also lease property from the United States of America or the federal government, basically, or any other federal agency for a term not to exceed 50 years. Any lease has to be approved by 2/3 of the park board, so just be careful about that. There's a supermajority vote if the commissioners are going to be approving a lease of park district, or if the park district is going to be leasing property. Post-acquisition issues. So those are the few options on how you can acquire property generally. One of the issues that comes up a lot after park districts acquire property is making sure that the property obtains its tax exempt status. So property held by a park district is not going to be subject to real property taxes. So you just want to make sure you go through the process to obtain that. It's not automatic. So after you obtain a new parcel of property, or in some cases where you have leased property, you have to file an application with the County Board of Review to essentially say, please take this property off the tax rolls. And so it includes, it's not too much of a lengthy application, but you have to include an affidavit of use saying that you're using it for a tax exempt purpose. You have to include pictures, usually a deed, sometimes a survey, lots of photographs of what you're going to be doing. And then other times the county might have other specific requirements that they want you to provide, such as a prior tax bill or a subdivision plat, or other specifics that the county might require. And then the county's going to look at that. They're going to file or forward it to the Illinois Department of Revenue. They're eventually going to make a decision about whether or not that property is being used for a tax exempt purpose, and then they'll give you that exemption. Sometimes it might be prorated depending on when the park district took title. So if you took title in, halfway through the year, it's going to be tax exempt prorated for 50% of that year. So whoever held the property prior to that is still going to be subject to those property taxes that were levied before they convey title to the park district. Also remember that you do have to annually file an affidavit that the tax exempt use is still in effect. So keep a list of that. What we recommend for our park district clients is keeping an inventory of all the parcels held by the park district, so that you know what you have, and then when you're filing those affidavits of use, so that you don't actually, you don't end up having a property fall back onto the tax rolls there. Because if that happens, there are some options here. It does happen on occasion where a property owned by a park district is inadvertently put back on the tax rolls. You can get a certificate of error where you're basically working with the county to say, no, this really was used for a tax exempt purpose. So the levy and taxes on that was an error. And sometimes I hope it doesn't ever get to this. We certainly hope none of our clients ever have to deal with this, or any park district, where a property is sold at a tax sale because there wasn't any, for some reason it fell through the cracks that taxes were being levied and not paid, and then they were sold through a scavenger sale. You can get a sale and error, establish that as well, but that's a little bit more complicated. So to avoid that, make sure you have an inventory of your property and ensure that you're staying up to date on the tax exempt status for all of those properties as well. Easements are another thing that you want to look at just as far before you're obtaining property, and as part of any post property acquisition as well. Park districts can grant licenses, easements, and rights of way to municipalities or other persons for utilities, water, sewer, public, gas, things like that. So basically utility easements. Park districts will very often receive requests from utility companies to grant easements across their properties. Make sure that if there is going to be a request for an easement over park district property, that it's documented in an easement agreement. And sometimes you might be able to require compensation if that easement is going to really impact the park district's use. Again, just like with donation agreements, always make sure that you have an easement agreement.
One other quick note on easements too, Kurt. So this has come up in for several clients. A lot of park projects and property acquisition involves OSLAD funding. And the terms of those OSLAD grants are particularly onerous as it comes to easements. And they don't allow the park district to grant rights to other parties, to third parties, to either access or use the property in many cases. But a lot of the grant terms only specifically reference easements. So a potential workaround that we've had some success with is if you have a municipality or other utility provider that needs access to a park that's encumbered or supported by an OSLAD grant, is to use a license agreement instead. Those don't appear to run afoul of many of the OSLAD terms we've reviewed. The trick instead is just trying to get either the municipality or the utility provider to get comfortable with the concept of a license instead of an easement. They are two distinct legal concepts, although you can certainly draft a license agreement to look a whole lot like an easement agreement and provide comparable rights at any rate. So just my 2 cents on that.
That's a great point. I know a lot of our clients have been in a lot of park districts across the state, have received OSLAC grants over the past year and a half here, and are in the process of completing those projects. So great point, great point. So that's easements. Now we're going to move on to some specific methods for how park districts can sell or lease their own property. So that was how park districts can acquire property. Now we're going to talk about how park districts can sell or lease their own property. You can obviously lease park district property. You can sell property to a private entity, or you can convey property to a governmental entity. And there's different procedures for all of those specific options here. So we'll go through them one by one, just so that everybody has the basics here. Park districts can lease unneeded property. So any district owning or holding real estate that the park district board deems is not required for park recreational purposes can lease that real estate to any individual and collect rent. The real only restriction here is that the lease cannot exceed 50 years. So pretty broad grant of authority to lease property. You can also restrict, there's an option to have restricted use or substitute property leases, where a park district can lease that property to another unit of local government or to the state or to any Illinois corporation for public use, but the lessee has to commit to holding and maintaining that property as a public park or for recreational purposes, or to provide property of substantially the same size or larger for park purposes without additional costs to the park district. So this is where you're basically saying it needs to stay in use as a park district property or for park district purposes, but it's going to be operated by a different entity, or they're going to be providing separate property for the park district to use for additional park purposes. So those are the two options that park districts have to lease property. Now the sale of park district property, this can be complicated. There's a lot of restrictions how and when park districts can sell real property. So the first option is restricted use or substitute property conveyances, and this is kind of the same idea as the leasing there, where a park district can sell property to another unit of federal, state, or local government, but that unit of government has to commit to maintaining the property as a park or for recreational purposes, or they have to provide the park district with substantially the same size land or greater for park purposes. So that's kind of this exchange there, or it's where the other unit of government is agreeing to maintain that land in perpetuity for park purposes. The other option, which we've already touched on, is the Local Government Property Transfer Act. Again, this is a really streamlined process that allows park districts and other units of government to convey property without having to follow some of the more burdensome regulations that would apply if the property was being conveyed to a private entity. So that's going to be something that you'll want to look at and that a lot of clients use when they're conveying property between governmental entities. There's also an option in the Park District Code to transfer, well, it's actually, sorry, the Park Commissioners Land Conveyance Act that is essentially an outdated mechanism that allows a park district to convey property to a city. I think it might not really be applicable, or at least it might not be as useful now that the Local Government Property Transfer Act is in effect. I think that would probably be the easier option there, because in that case, the Park Commissioners Land Conveyance Act requires that the district receive approval through a referendum, and that's obviously a difficult process and requires a lot of work, whereas the Local Government Property Transfer Act does not require a referendum for a park district to convey property to another unit of government there. So those are the options on how you're going to convey property to another governmental entity. Where it gets real complicated is where a park district wants to sell property to a private entity, usually for profit. there's some special legislation. There's been actually several special legislation or several types of special legislation to allow park districts to sell land to private entities. Right now, the Park District Code has special legislation for park districts in Madison and St. Clair counties in specific municipalities to sell property. And there used to, I think the legislation has expired, but there used to be special legislation that gave a window for some park districts to sell golf courses without having to follow certain procedures. That has not been renewed. So I know that many park districts hold golf courses, and you know, I'm certainly familiar that a lot of golf courses have hit hard times over the past few years, and there's not a real easy way, or at least that legislation, the special legislation, doesn't allow or isn't in effect anymore to allow a park district to offload a golf course very easily. So you'd have to look at some of the other methods, which I'll touch on right now. So there's a sale by referendum. This is if you're going to sell a golf course, if you're going to sell another large piece of property that's owned by the park district, you have to go through a referendum. So to start that process, the park board has to adopt a resolution by a 4/5 vote that includes a description of the property, declares that the land is no longer needed for park purposes, and that the board intends to sell the land. You have to publish that. You have to publish notice of this adoption of that resolution several times. And after you have adopted that resolution and there's been notice, you have to certify that question to the proper election officials, and then you have to have the referendum held. So if the referendum is approved, the board has to conduct a public auction to sell the property. So before the auction, the board has to publish notice and say, here's when the sale is going to be conducted, here's when we need bids, and here's are the specific terms that we're looking at for the purchase of that property. The auction, the board is mandated to sell the property to the highest responsible bidder at the auction. The purchaser has to pay at least 1/3 of the purchase price in cash at the time of the sale, and then pay the remaining balance in 2 equal payments. The first due within 6 months of the sale, and the second due within 12 months of the sale. So it's a pretty strict process. It doesn't give a park district a lot of leeway on who the property is sold to, or how that sale is structured. The board would still reserve the right to reject any and all bids. So if you went out to bid, you had a referendum passed to sell a piece of property, but all the bids came in significantly lower than the park district was expecting, you wouldn't have to accept all those bids. You could rebid it anytime within the first 12 months of that referendum being approved. But after that 12 months have expired, you can't continue to advertise that property for sale. You'd have to go through another referendum to get authorization to sell it. So it's not a real easy process for park districts to sell large pieces of land. And if you do, it's a complicated process. So if you are looking at selling a large piece of land, you know, obviously consult with your attorney, look at different options. If you have a piece of land that's no longer useful, talk with your other adjoining governments or overlapping governments and see if there's a way that they can put that land to use as well. And you can follow the Local Government Property Transfer Act instead of having to try and go out through the bidding process there. There's also, if it's a smaller piece of property, if it's 3 acres or less, there is an expedited method here for a park district to convey property to a private entity. It does not involve a referendum, but it does involve the court. So if you're selling a piece of land that's less than 3 acres, you can apply to the circuit court in your county for basically approval from the judge to sell the property. You have to publish notice. The public has, and anybody who's opposed has the right to appear in court and object. But after that, the court can direct the sale of the property, and you basically would have that set up. You'd have, in most cases, you'd have a purchase and sale agreement already at least drafted with who you intend to sell that property to. So the court knows the terms of it before they review that as part of your petition there. So there is a non-referendum option there to sell property, but only if it's 3 acres and less, and it still does involve the court. So not a lot of easy ways for park districts to sell property, and I think that's why in most cases, park districts look to other units of local government because that process is a lot easier. So now we'll get into a few case studies here about park districts and their attempts to convey land to private properties, because there's actually been a significant amount of litigation involving the attempted sale of park property. One that actually our office handled a few years ago involved the Park District of LaGrange. The Park District decided that they wanted to sell a portion of the land that was less than 3 acres. They didn't see any need for it anymore, and they were going to sell it under the under the provisions of the Park District Code that allowed them to petition the court to have the property be sold. The Park District decided that it was no longer useful. But when they went and tried to sell it, an entity called Friends of the Parks, basically, or LaGrange Friends of the Parks, filed an objection while it was the petition had been filed in court. Filed an objection with the court saying that they believed the conveyance of the property violated what's called the public trust doctrine, and that's this kind of arcane legal theory that land that has been dedicated to public use is held in trust for the public, so that the government entity isn't owning it in their own right, they're holding it in trust for the public, so they can't eliminate that public use once it is held in the public trust. It's really only ever been applied, or at least in most cases, has been applied to submerged lands that the city of Chicago has attempted to sell that have been reclaimed. But in this case, the Friends of the LaGrange Parks challenged that. The court in the circuit court found that there was no claim there, and they ordered the land to be sold at the average cost of the 3 appraisals for the land. But the objector appealed and brought it up to the appellate court. And they claimed that since there was also an adjoining parcel that was being sold as well that was less than 3 acres, that this was an attempt by the Park District to kind of get around that requirement that mandated a referendum to sell a larger piece of land. The court said there was no merit to that argument, that the act allows the Park District to transfer more than one parcel within one park in separate transactions. So this wasn't some type of impermissible subterfuge to get around the limitations of the park code there. There were also some challenges to whether or not the Park District Code violated the Separation of Powers Act, where it required a court to make a determination on what was in the public interest. That was also rejected. The court found that the act confers on the authority on the Park District, not the trial court, to make the initial determination that parkland is no longer needed, necessary, useful, and that the sale would be in the public's interest. So that determination of what's in the public interest is actually still up to the Park District. And then finally, there was some challenge about whether or not there was any, beneficial interest there. And the court said there was more than enough evidence presented by the Park District that there was no need for the property, and that it was more beneficial to the Park District and the public health and welfare for them to sell the property, and that it was a rational means to accomplish a legitimate purpose for the Park District there. So that was one instance where a Park District's attempt to sell property was approved. The next one is, everybody might remember this, is the Lucas Museum, the George Lucas Museum that was proposed to go just south of McCormick Center there on the lakefront. The Lucas Museum, they had worked out an MOU, or Memorandum of Understanding, with the city of Chicago to basically take a very, very long-term lease for this land and construct this museum. The General Assembly actually passed a statute authorizing museums and presidential libraries and public parks, including those on formerly submerged land, which, again, that's the classic cases on the public trust doctrine have only applied to previously submerged land, because all land that's submerged under navigable waters is held in the public trust. When that land becomes no longer submerged, it's still held in the public trust. And that was the argument here, that this was still violating the public trust doctrine. There was a lawsuit. The Friends of the Chicago Parks filed a suit trying to stop the museum from going in. They argued that this ground lease was in violation of the public trust doctrine. But it didn't really get that far. There were some initial hearings at the circuit court level The court acknowledged that the public trust doctrine does not grant a right for proximity to public parks designated by a specific purpose. So the Friends of the Park were saying that we have a right to be close to a park for this purpose, for recreational purposes. The court said that's not really what the public trust doctrine applies. But the court did find that there was sufficient allegations that the dedication of this land or the use of this land by the Lucas Museum was enough to say that there was a violation of the public trust doctrine. They said that basically the General Assembly delegated the authority to decide whether or not land is held in the public trust to the city and the Chicago Park District, which they potentially could not do. Ultimately, there was no final resolution to this case. I guess George Lucas decided that he wanted to see the museum built within his lifetime. So he basically gave up and shopped it around and ultimately decided on building it in LA. Would he ultimately have prevailed and been able to install the museum? Probably. We think that he probably likely would have won. But it's just another case that shows that whenever you're going to be conveying Park District property, be really careful, have it studied closely, because there are a lot of challenges out there on the public trust doctrine. Next case study here again involves the Chicago lakefront, this time for the Barack Obama Presidential Library, which he has chosen Jackson Park on the lakefront there for his library. There was a lawsuit filed in federal court by the Friends of the Park. They again challenged that the use of the Park District's land for the Obama Presidential Library violated the public trust doctrine because the land was being used for a private purpose, was the allegation there. They also alleged that there were some other federal claims that the taking of this land held in the public trust was a unconstitutional taking of their property rights, because they, as residents who were able to enjoy this land dedicated to the public trust, could not have that land taken away from them without it being a taking under the Fifth Amendment. This was filed in federal court, and it went up to the Seventh Circuit. Seventh Circuit went through a pretty lengthy analysis of the public trust doctrine under Illinois law and why Illinois has allowed this doctrine to be upheld several times for certain types of parkland like this. But the federal court, the Seventh Circuit, said that's not enough for federal standing. They said under federal law, to say that you have standing to bring suit to challenge the public trust, you have to show that you suffered some damage different than the general public. And the Friends of the Park were just residents who, along with all the other residents of the city of Chicago, were injured in the same manner, that this land was now being dedicated to use for the Obama Presidential Library. The Seventh Circuit said that wasn't enough for standing in federal court, that while Illinois law may allow any resident who has access to that park to sue in for a violation of the public trust doctrine, under federal law, that's not enough. So they dismissed the federal claims and said that there wasn't really anything here, but they said the public trust doctrine, we don't have jurisdiction, that should be brought in state court. So there might still be some ongoing challenges there, but from what we can tell, it looks like the Obama Library will move forward. So those are some case studies there. Again, just kind of shows you, be careful when you're selling property, really look at it. If it's property that was dedicated to the Park District through a plat, always look at the plat, make sure that you're being consistent with that, because sometimes those can raise issues with restrictions and whether or not the Park District can convey that land in the future, especially if there's a statutory dedication where it says the land has been conveyed or dedicated in perpetuity for use as a public park. That can cause some problems there. So look closely when you're selling property. Then just some general touch base quickly on this property management strategies once you have acquired the property. So you can, one way that a lot of park districts have kind of come up with to manage property is to have a charitable foundation either hold the property or manage the property. The supporting not-for-profit can hold the assets of the park district, including real estate. They can accept donations and assets that can eventually be conveyed to the park district if they let, to support the park district's programs. And that not-for-profit entity is generally not going to be subject to the same limitations that a park district would be when it comes to buying and selling land. So that's one process to look at that your park district might consider for either holding or managing properties through a not-for-profit corporation. It is a little tedious to set up. You have to file lots of forms with the state and the federal government to establish that not-for-profit and bylaws and things of that nature, but it can be a useful tool. So that might be something that your park district look at. And then I think that's all I have. And we have finally the after slide here, just showing what the project's going to look like when you have finally gone through all of the zoning, acquisition, and sale, or potentially sale process here.
Yes. Like any good park, they cut all the trees down. No, but they got some great programmable space out of it. It's a huge success. It's a beautiful facility. After at the end of all of those long steps, this is what's important. This is why they started down this path in the first place. Which brings us to what would be the question slide, but really it's just Kurt and I sitting talking at our computers. But if you do have any questions after you view this presentation and you've made it this far, one, thank you. Two, Kurt's contact information and my contact information is on here. Always fun participating in IAPD events and
always
happy to answer any questions anyone has.
Absolutely.
Okay, thank you all. Happy 2021.
Yes, thanks for attending.
Thanks, Greg and Kurt. That was great. A refreshing session from the 2021 IAPD IPRA Soaring to New Heights Conference. But it is a regular meeting, and we do have to have public comment. Internet user Clifton Data Editor writes, our rules for public comment express the chair of the meeting may cut off comment when it becomes disruptive or abusive. What type of conduct meets this standard? Well, Clifton, many public bodies have rules which prohibit disruptive behavior or abusive language, but they are not frequently used to curtail public comment. In a recent opinion, an advisory opinion, from the Public Access Counselor of the Illinois Attorney General's Office, in which the meeting took place virtually over a web conference platform, the chair of the meeting muted the speakers allegedly making abusive personal attacks against named city officials and employees. On review, the Public Access Counselor, or PAC, cautioned that content-based restrictions must be narrowly construed and public comments pertaining to matters of public concern are protected by the First Amendment, even if the speaker's motive in commenting could be an insensitive, mean-spirited personal attack. Further, PAC highlighted that Section 2.06G of the Open Meetings Act does not permit a public body to apply public comment rules that are susceptible to overbroad and arbitrary application to comments that do not actually disrupt public meetings. After reviewing the verbatim recordings, the PAC indicated that comments made by the speakers were delivered in a calm manner. It did not contain profane language and did not create a disturbance or otherwise interfere with the efficiency of the meeting. As a result, PAC found no evidence that it was necessary to mute either of the speakers to maintain decorum. Now, this is another example of the Public Access Counselor kind of wading into First Amendment territory in its advisory opinions. That is increasingly common and arguably not something that is within the jurisdiction of the limited authority the Public Access Counselor might have under the Open Meetings Act. Nevertheless, you could check out more about this and the advisory opinion on the Municipal Minute blog from Hansel Glink. We'll include a link to this blog post in the show notes. Which brings us to the Department of Public Works. As we mentioned earlier, the call for proposals for the 2022 IAPD IPRA Soaring to New Heights Conference is now open. submit a proposal. Visit ioparksconference.com. Deadline's June 14th, 2021. Ansel Glink is at the conference every year. We look forward to participating. And we want to hear what you, dear listeners, want to hear about at the conference. So please consider emailing us at podcast@anselglink.com. And of course, if you want to submit your own session proposal, IAPD, IPRA encourages you all to submit to that conference portal that's in the show notes and at ioparksconference.com. How about it? Well, before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com. And as always, you can visit us online at quorumforum.anselglink.com. Can we get a motion to adjourn? Second, all in favor, the ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast.